On May 15, 1911, the Supreme Court of the United States issued one of the most celebrated antitrust rulings in American legal history. The court found Standard Oil an unreasonable monopoly under the Sherman Antitrust Act and ordered it broken into more than 30 independent companies, each with its own board, its own management structure, its own legal identity. Every newspaper in the country described it as a decisive victory over concentrated corporate power. The trust had been defeated. The state had prevailed. What happened in the 24 months that followed is what almost nobody discusses. The shares of the newly independent companies rose between 65 and 125% in the months following their separate listing on the stock exchange. Rockefeller held approximately 25% of each successor entity because he had owned a quarter of Standard Oil, and the court's dissolution translated his stake proportionally across every company that emerged from it. His personal fortune, documented in multiple historical analyses of the antitrust proceedings and subsequent market records, went from approximately $300 million in 1911 to $900 million by 1913. In less than 2 years, the man who had been officially punished by the highest court in the country had tripled his wealth. And here is what nobody tells us about this moment. What the United States government presented to the public as a decisive defeat was, by every financial metric that exists, the single most profitable event of John D. Rockefeller's entire career. Not before the ruling, because of it. The monopoly structure had suppressed the visible value of its own components. Breaking it open forced a market discovery, and the man who held a quarter of everything that emerged was the primary beneficiary of that discovery. That is the paradox at the center of this video. When we look at it carefully, not as a story of justice, but as a study in how power actually behaves under institutional pressure, what we see is not an anomaly. It's a pattern that repeats across industries, across decades, across legal systems. A monopoly that learned to survive its own dismantling, and a playbook that outlived Standard Oil by more than a century. To understand how this was possible, we need to go back 48 years, to Cleveland, Ohio, 1863. What Rockefeller found there was not a business opportunity in the conventional sense. It was an architecture of power that had not yet been assembled, and when I first looked at the speed with which he built it, I found myself checking the numbers twice before accepting what they showed. In 1859, the first commercial oil well in American history was drilled in Titusville, Pennsylvania, roughly 100 miles south of Cleveland. The industry that erupted around it was, by any modern standard, a study in structural chaos. Prices for refined petroleum could swing by 400% within a single month. Refiners competed on margins so thin that a single bad quarter could eliminate years of accumulated capital. The commodity itself existed in extraordinary abundance. What did not exist was any reliable infrastructure for processing or moving it. Rockefeller entered this environment in 1863, aged 24. As a partner in a Cleveland refinery. He had no particular expertise in petroleum chemistry. What he had was an analytical clarity about what actually determined survival in a volatile commodity business. And what he saw, clearly enough to bet his entire capital on it, was that the critical variable was not production. Production was geological and uncontrollable. The variable that could be controlled was logistics. Who moved petroleum from the fields to the refineries, and from the refineries to consumers, at what cost and on what terms. That single insight would become the structural foundation of the most concentrated industrial empire the United States had ever produced. In 1870, Rockefeller incorporated the Standard Oil Company of Ohio with $1 million in initial capital. What followed over the next decade is one of the most rapid market consolidations in the history of industrial capitalism. By 1880, Standard Oil controlled between 90 and 95% of all refined oil produced in the United States, according to records from Encyclopedia Britannica and the antitrust proceedings that eventually dismantled it. A company founded with $1 million a decade earlier controlled the refining infrastructure of the world's fastest-growing energy economy. By 1904, 7 years before the Supreme Court ruled against it, Standard controlled 91% of oil refinement and 85% of final sales in the United States. What we need to understand, before everything that comes next in this analysis, is not the fact of that dominance. It's the mechanism that produced it. Because the mechanism explains why the legal intervention of 1911 generated the financial outcome it did. For context, the period from 1870 to 1910, encompassing Standard Oil's rise and its consolidation at the top of the American economy, was precisely the window Thomas Piketty documented in Capital in the 21st century as a phase of extraordinary private capital accumulation. The capital-to-national income ratio in the United States rose from roughly 300% to over 500% during these decades. Piketty's argument is that this was not exceptional in the history of capitalism. It was the default trajectory of market economies in the absence of redistributive shocks. The concentration Rockefeller achieved didn't happen in spite of the system. It happened because the system, in its natural state, rewards whoever arrives first with sufficient capital to build the barriers. In 1863, there were no barriers. Rockefeller built them. The velocity of that construction is the first anomaly of this story. But velocity is not the most important element here. What I want to show now is the method, because what Rockefeller built between 1870 and 1882 was not simply more aggressive competition. It was architecturally different. And I'll show each layer precisely, because understanding these layers is what makes every subsequent development comprehensible. The first layer was the railroad rebate system, and it operated in a way that most standard accounts of Standard Oil don't fully convey. Rockefeller's shipping volume gave him genuine leverage to negotiate private discount rates. He was moving more oil than any other entity on any railroad in the country, and railroads had strong incentives to secure that volume at reliable terms. That much is well documented, but the mechanism went considerably further. Through arrangements most prominently associated with the South Improvement Company and subsequent railroad agreements, Standard Oil obtained what the historical and legal record calls drawbacks. A portion of the shipping fees paid by its competitors was redirected through the railroad companies back to Standard Oil's account. According to the antitrust proceedings and academic analysis of the rate structure published in legal journals examining the centennial of the case, independent refiners were paying the public tariff posted by the railroads, and a fraction of that payment was flowing, invisibly and automatically, into Rockefeller's treasury. And here is what has fascinated me about this mechanism every time I have returned to the primary sources. The competitors were, with no awareness of the arrangement, subsidizing the company that was systematically eliminating them. Every barrel they shipped at the public rate was a contribution, however marginal, to the enterprise absorbing or destroying their business. The rivals financed their own elimination. This was not aggressive competition. It was a mechanism by which the competitive act itself generated revenue for the dominant player. The second layer was vertical integration so structurally complete that it severed Standard's dependence on any external service provider. Standard didn't simply refine oil. It built pipelines to transport crude from the fields. It acquired barrel factories, chemical byproduct operations, and distribution networks. By the mid-1870s, every cost that an independent competitor had to pay as an external market transaction, Standard had converted into an internal cost it controlled and continuously optimized. A competitor who had to negotiate for barrel production, pipeline access, and rail rates at external market prices was structurally unable to match the internal cost structure of an entity that owned all of those functions outright. The efficiency advantage this created was not marginal. It was, in practical terms, structural. The savings were not passed to consumers. They were accumulated as capital and deployed into the next acquisition or competitive elimination. The third layer is the one most directly responsible for the paradox of 1911, and the one with the longest afterlife in corporate and political history. In January 1882, Standard Oil's chief attorney, Samuel Dodd, created a legal structure with no direct precedent in American corporate law. On January 2nd of that year, 41 investors signed the Standard Oil Trust Agreement, which pooled the securities of 40 companies under the unified control of 9 trustees, including Rockefeller. Shareholders of the underlying companies transferred their ownership certificates to the trustees in exchange for trust certificates denominated at $100 each. The trustees exercised complete operational and strategic control over all entities in the system. And critically, in any public record, any state corporate registry, any regulatory inquiry, What was visible was a collection of apparently independent companies operating across different states. What was invisible was the single unified intelligence directing all of them. When I encountered this structure in the primary source materials, the trust agreement itself, the Supreme Court briefs, the historical analyses of the case, the first thing I thought was, this was engineered for invisibility. Ida Tarbell, who spent years investigating Standard Oil for McClure's magazine, wrote that you could argue the trust's existence from its effects, but you could not prove it by examining any single company's filings. That opacity was not incidental to the structure. It was the structure's primary engineering objective. When Ohio moved against the trust in 1892, its Supreme Court ordered it dissolved. Standard reorganized its holding company in New Jersey, whose corporate laws, according to historical records of the period, had been shaped by interests aligned with precisely these structures. The regulatory threat didn't eliminate the mechanism. It forced a jurisdictional adaptation that made the structure more distributed, harder to attack through any single state's authority, and therefore more durable than it had been before the challenge. The trust, in one form or another, operated for 29 years. In 1911, the Supreme Court finally dismantled it, and the man at its center tripled his fortune within 24 months of the ruling. That is the outcome we need to examine before turning to what happened next. The trust ran for 29 years. In May 1911, the government dissolved it. And here is what fascinates me most about this part of the story, because this is precisely the moment when most accounts of Standard Oil stop paying close attention, and exactly when the analysis becomes most instructive. The conventional narrative of the 1911 ruling is straightforward: a monopoly punished, competition restored, the public interest vindicated. That reading is not incorrect, but it describes the legal surface of the event without examining the capital mechanics operating underneath it. When Rockefeller held a quarter of Standard Oil, that quarter represented a stake in a single entity that was not publicly traded, issued no annual reports, and operated as a consolidated structure whose component parts had never been independently priced by any market. The trust had, for its entire existence, suppressed the discoverable value of the businesses it contained. Smaller, more focused regional operators, which could have functioned as independent growth companies in a genuinely competitive market, had been absorbed into a system designed for unified control, not for independent valuation. The market had never had the opportunity to price them separately. The dissolution created that opportunity. According to the historical record of the case and subsequent analysis of the market data available from that period, shares of the successor companies rose between 65% and 125% in the months following their independent listing. Rockefeller's documented net worth went from approximately $300 million to $900 million between 1911 and 1913. The patent reading of that outcome is that the breakup enriched the monopolist. The deeper reading, the one that matters for what comes after, is that the monopoly structure had itself been suppressing its own market value. The government's intervention did not reverse the underlying accumulation logic. It forced a price discovery event that revealed value the monopoly's opacity had concealed. And what me interests is not the legal outcome, but the structural lesson. Rockefeller didn't lose control. He redistributed his ownership into a form that no single regulatory action could attack as a unified entity, while the market simultaneously assigned higher values to each of its components than the consolidated structure had ever made visible. The second case arrived 87 years later in a completely different sector, and the structural parallel is close enough to be more than coincidence. In 1998, when the Department of Justice filed its antitrust complaint against Microsoft, the company had, according to reporting from the period, minimal formal government relations infrastructure in Washington. A front-page story in the New York Times in December 1997 had described Microsoft as having virtually ignored the Washington political environment until the Justice Department investigation was already underway. The company had built extraordinary market dominance. Its operating system ran on over 90% of the world's personal computers, and had operated on the assumption that technological market leadership was self-sustaining protection against institutional challenge. The DOJ filed its antitrust complaint on May 18, 1998, joined by the attorneys general of 20 states. The government alleged that Microsoft had used its operating system monopoly to extend control into the browser market through predatory bundling and exclusionary practices against competitors, including Netscape. What the government sought, ultimately, was structural separation, the breakup of Microsoft into distinct operating system and applications businesses. A court ordered precisely that in June 2000. But what may interest in the Microsoft case is not the eventual legal settlement. It is what Microsoft built during the 3 years between the filing and the resolution. According to Fortune magazine's 2002 investigation of Microsoft's political transformation, the company undertook what the publication described as the largest government affairs makeover in corporate history following the 1998 filing. It staffed a previously minimal Washington presence with significant resources. According to the Washington Post's March 1998 reporting, it had by that point hired 4 former members of Congress and 32 former congressional staffers or government officials as lobbyists. It retained senior operatives from both parties. It funded full-page advertisements in the Washington Post and New York Times framing the antitrust action as government interference with technological innovation, signed by 240 economists. It provided institutional support to think tanks constructing an intellectual framework arguing that antitrust law designed for industrial-age monopolies was being misapplied in a fast-moving technology market. The antitrust action was settled in November 2001. The breakup order was overturned on appeal. Microsoft was not dissolved. The most consequential outcome of the entire proceeding was not the legal settlement. It was the institutional infrastructure Microsoft had constructed in response to a threat it had initially chosen to ignore. A company that had operated with disdain for government engagement had built, under regulatory pressure, the political architecture it retained and deployed indefinitely after the threat had passed. The challenge upgraded the capability. The pattern from 1882 is architecturally identical. Standard Oil under antitrust threat. Build the invisible legal structure that no single jurisdiction can attack. Microsoft under antitrust threat. Build the political infrastructure that reframes what regulation can legitimately target. In both cases, the entity that survived the challenge emerged more institutionally embedded, more structurally durable than it had been before the government acted. The regulatory intervention did not reverse the accumulation logic. It forced it to evolve. Standard Oil in 1882, Microsoft in 1998. A century apart, 2 different industries, 2 different legal tools. But when we look at the full sequence, regulatory threat, adaptive structural response, survival, and institutional consolidation, what we're looking at is not historical coincidence. It is a repeatable pattern. And what may interest now is what that pattern tells us about the structural logic underneath it. There is an economic framework that makes the paradox of 1911 and the Microsoft transformation of 1998 legible as expressions of the same underlying dynamic rather than exceptional historical anomalies. I found it not in a business history, but in the mathematical argument Thomas Piketty constructed in Capital in the 21st century, and when I read it in full, it genuinely became difficult to see the preceding 2 centuries of economic organization without adjustment. Piketty's central formulation, R greater than G, states that when the rate of return on capital consistently exceeds the rate of economic growth, the share of national income flowing to capital owners rises indefinitely relative to the share available to everyone else. The mechanism doesn't require exploitation to produce its outcome. It operates as arithmetic. If capital generates returns of 5 to 7% annually, while the broader economy grows at 2%, the gap between those who hold capital and those who do not widens continuously through the mathematics of compounding without any additional action by the capital holder. Piketty's analysis of Forbes billionaire data from 1987 to 2013, published in Capital in the 21st century, found that the largest private fortunes grew at an average of 6 to 7% per year above inflation, roughly 3 times the rate at which average global wealth grew over the same period. This differential is not marginal in its long-term implications. A fortune growing at 6% annually becomes more than 5 times larger over 30 years. A fortune growing at 2% becomes roughly 1.8 times larger. The compounding gap is not a factor of 2 or 3. Over a generation, it approaches an order of magnitude. This is what the 1911 data actually demonstrates. Rockefeller's wealth tripled not because the government miscalculated its remedy. It tripled because the capital held within the trust structure was worth more as independently traded components in a competitive market than it had been as a unified monopoly preventing any independent price discovery. They are greater than G logic was not interrupted by the dissolution. It was accelerated by the market discovery the dissolution forced. The regulatory intervention changed the legal form of the capital's organization without affecting the direction of its accumulation. The second implication of this framework is one we discuss far less than the wealth concentration dynamic itself. Capital generated by industrial activity does not remain in the geographic communities where that activity occurs. The communities that built the physical infrastructure of Standard Oil, the refineries of Cleveland, the pipelines across Ohio and Pennsylvania, the transport corridors between the oil fields and the eastern cities, did not retain the capital those operations generated. Cleveland, which in 1880 was the center of the world's largest refining operation, did not become a major financial capital. The capital migrated from operating companies to trust certificates to holding structures to instruments of ownership increasingly detached from any specific geography or any specific labor force. The regions that produce capital are, as a structural matter, different from the regions that accumulate it. The third implication connects the 19th century to the present in a way that becomes, once you see it, genuinely difficult to ignore. According to documented campaign finance records from this period, the share of American political spending flowing from groups that did not disclose their donors rose from approximately 2% in 2006 to roughly 40% by 2010, masking hundreds of millions of dollars in political influence. The legal instruments had changed. Trusts had been replaced by nonprofits. Drawback arrangements had been replaced by donor-obscured political networks operating through layered organizational structures. The architecture of invisibility had been preserved and adapted to the regulatory environment that had evolved to address its previous forms. The structure changed. The function did not. And when we look at the largest private fortunes through this lens, fortunes growing at 6 to 7% above inflation annually, compounding across decades, generating returns that the broader economy cannot match by structural definition, the question this framework puts in front of us is unavoidable. Then, what does antitrust regulation actually protect? The most honest answer I've found, after working through these cases from 1870 to the present, is this: it protects a narrative. The narrative that concentrated market power is governable, that the institutional frameworks we use to organize economic competition have binding authority over entities that operate within them, that the public interest, expressed through law and enforced by courts and regulators, can check accumulation when it exceeds what the political community will accept. That narrative carries genuine political and social value. It sustains the democratic legitimacy of the regulatory state. It creates the conditions under which people continue to trust that the formal rules of competition apply to everyone, including the most powerful entities in the economy. That is not a small thing. What it does not change is the underlying logic Piketty describes with mathematical precision. Antitrust enforcement, at its most effective, forces adaptation. Adaptation, at its most sophisticated, produces structures more institutionally embedded and more legally durable than the ones the regulatory challenge originally targeted. The trust of 1882 lasted 29 years and tripled its architect's wealth when it ended. The Microsoft antitrust action produced an institutional infrastructure that the company retained indefinitely after the legal threat had passed. According to Federal Reserve distributional data, the top 1% of American households held approximately 31 to 38% of total private wealth in the most recent measurement periods, a concentration that, in its structural proportions, is comparable to the period immediately preceding the Great Depression. What changes is the sector, the jurisdiction, and the specific legal instrument used to achieve invisibility. What does not change is the direction of capital. And when we genuinely understand that, when we hold the full arc from Cleveland in 1863 to the present, it becomes very difficult to look at any major corporation facing regulatory scrutiny and see only a company being held accountable. What we are watching, in most of these cases, is a system in the process of becoming more sophisticated, more distributed, harder to identify within any single legal structure, more deeply embedded in the environments that would otherwise constrain it. The question this video leaves us with is not whether regulation is useful, it is what we mean when we say it works. And the more carefully we examine the evidence that stretches from the Standard Oil dissolution through to today, the more clearly that question demands a more precise answer than the official narrative provides.